Negligence is the most tested single issue on the multi-state bar examination. Negligence is worth roughly 14 questions out of the 200 that are present on the MBE. And negligence is very commonly tested on the essays also. Most of us know the elements by heart, and if you don't, you need to stop everything and memorize them right now. To establish a claim for negligence, a plaintiff has to show duty, breach, causation, and damages subject to any defenses that the defendant might want to offer into evidence. Now, there's one other issue floating around in negligence, and that's the issue of foreseeability. Foreseeability is not technically an element of negligence, but it's an idea that permeates most of the elements of negligence. So first, we will see foreseeability with regard to duty, which implicitly means breach as well. We will see foreseeability issues in proximate cause, and we'll see them again in damages. So this idea of foreseeability is present throughout negligence, even though it is not itself an element of the theory of liability. So let's just get right into considering each of these elements in turn. To begin with, we consider duty. And we need to acknowledge that in negligence, typically we are being tested on fact situations where the defendant does something careless. But it's also worth acknowledging that a failure to act sometimes also be considered a breach of duty. Also, we turn to whether or not a plaintiff is foreseeable. And most of us, I think, as we enter law school perhaps with the Andrews view of foreseeability. We figure if somebody is injured as a result of carelessness by somebody else, the injured party ought to be able to collect. But as we get educated, we find that's not exactly true. We find that the Andrews view actually is a minority view, and that the Cardozo view, a plaintiff has to be in the zone of danger in order to be able to recover in negligence, is actually the majority view about foreseeable plaintiffs. This is fodder for plenty of analysis on essay questions, and it also can be tested narrowly on the multi-state exam as well. We also see that there are issues of duty with regard to a defendant's responsibility for conduct of third parties. And these issues arise most commonly either with children or with an employer-employee relationship. Those are threshold issues relating to duty. Also, the idea of negligent entrustment arises with regard to a vehicle. If the vehicle owner lends his or her car to somebody else, knowing that the person who's about to borrow the car shouldn't be driving, that can give rise to a breach of duty claim against the owner of the car. But typically, car owners are not liable for the negligent acts of people to whom they loan their cars. We realize also up front that typically parents are not going to be liable for the torts of their children, although that is being modified by statute in a number of jurisdictions. Still, where a parent has knowledge that a child engages in certain careless or dangerous activities, the parent sometimes is required to protect the public from a dangerous child. Let's consider the standard of care. We're done with threshold considerations about duty, but the standard of care is one of the most simple and straightforward ideas in the law of negligence. All of us owe everybody else a reasonable standard of care. Never do we owe less than a reasonable standard of care, but sometimes we owe more than a reasonable standard of care. The most commonly tested situations in which a higher than ordinary care is required are those arising out of an innkeeper-customer relationship or out of a common carrier transport relationship, a taxi driver, a bus driver, a pilot, etc. Under those circumstances, a higher than ordinary standard of care is required. So an innkeeper or a common carrier has a greater level of duty than everybody else does. So, for example, someone who runs a restaurant or is responsible for transport services has a greater likelihood of a duty to warn somebody of an unsafe situation, whereas most of us do not owe any duty to strangers. we see that as we judge kids or people who are physically or emotionally handicapped, again, we do not lower the standard of care for them, but we recognize that they are not ordinary people, and we judge them by a reasonable standard based on, in a child's case, children of similar age and experience, and with handicapped people, we judge them based on the degree of their disability, and we figure out what would be reasonable to expect somebody with those problems to behave. So we consider physically handicapped people and children in a very similar way. Now, consider this. We also consider professionals in a very similar way to the way that we approach people with disabilities or children. We don't have an objective standard of judging professionals. We have sort of a sliding scale when you think about it. We look at similar professionals in similar jurisdictions. So we don't judge a business lawyer in a small town by the same standards that we would judge a big law firm associate in a Wall Street practice. Those are very different jurisdictions, and so we would adjust the standard of care accordingly. Very rarely in American law is there a duty to act. We don't have a duty to take care of ourselves. We may be our brother's keeper, but we are not the keeper of strangers. Where there is a family relationship, often there is a duty to act. We do have to take care of people, at least in our same family. But we can be walking on the beach, we can see some stranger drowning in 6 inches of water, and we can sit on the sand and light a joint and smoke that joint watching that person drown. We may incur criminal liability for drug offenses, but we're not going to incur civil liability for a failure to rescue, because we have no special relationship and there is no established legal duty. Now, suppose we begin to effect a rescue. At that point, we are assuming a duty and we have to act as a reasonable rescuer under the same circumstances. Where a defendant's carelessness has put somebody into a dangerous situation, then we have an affirmative duty to try to fix it and to try to save the person from harm. So if, as a result of the defendant's negligence, somebody who can't swim ends up in the water, that negligent defendant now has an affirmative duty to act to try to save the person who has been put in harm's way as a result of the conduct of that negligent defendant. Next, we turn to breach. Once we establish a duty, we turn to consider whether or not the defendant's conduct is bad enough to be considered a breach of the duty of reasonable care, unless a higher standard of care applies. We consider the custom and usage of the practices in the community related to this incident as we consider whether or not there's been a breach of duty. So, for example, suppose a plaintiff is bringing a claim for negligence against a dentist as a result of a dental procedure that has gone awry. Well, one of the dentist's defenses to a negligence action would be to say, every dentist does this act in this way. And as we've already briefly touched on, we'll judge a professional by a reasonable professional standard. And if all of the dentists are doing a particular procedure in the same way, that would certainly tend to show that our defendant was acting reasonably when he or she followed those same procedures. But let's take a step back for a moment. Suppose all of the dentists in the country are doing something carelessly. Well, part of what happens in the relationship between the law and medical and dental practice is the results in court sometimes dictate the practices in the clinic. So it is possible for a plaintiff to overcome a showing by a defendant that the defendant's practices are common in the defendant's industry. If everybody in the industry is careless, the plaintiff is still entitled to recover, because plaintiffs have a right to be protected from negligent conduct by defendants, and they have the right to be compensated. We see that where a defendant violates a statute and causes harm, we are able to establish a breach of duty by calling it negligence per se. So if we've got a plaintiff who is suing out of injuries arising from a traffic accident, and the defendant was both speeding and driving under the influence, it's not going to be very hard for the plaintiff to establish a breach of duty. Finally, we consider res ipsa loquitur. Res ipsa loquitur, the matter speaks for itself. This is another way for a plaintiff to establish a breach of duty. And probably the most common example of res ipsa loquitur is in the instance of a plane crash, where there's very little physical evidence left after the crash, and we've got the next of kin suing to try to establish negligence and to try to recover for the losses. And here, there's a basic standard three-part approach that we would use on an essay and that we would understand for multi-state purposes. First, the accident has to be of the type that doesn't occur absent somebody being careless. A plane crash fits that standard very nicely. The instrumentality of the harm is solely in the control of the defendant. Well, in a plane crash case, none of the plaintiffs are flying or operating the plane. And then finally, no fault by the plaintiff. So if we've got a plaintiff in an airplane who discharges a firearm several times, causing the crash, obviously that would be good enough for the defense to overcome a plaintiff's argument of res ipsa loquitur. And that wraps up a quick consideration of negligence up front, basic negligence ideas, and then breach of duty. In the next video, I will discuss causation, damages, and defenses, and that will then wrap up a consideration of the most testable issue on the multi-state, negligence.